Next, Justice Sotomayor got into a back and forth with Solicitor General Sauer.
So can I ask you a question? Your theory here is arguing that Article III and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both
bases.
of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide. But
we couldn't enforce it against universally, is your argument.
If there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
Interesting question. What are the limits on the Supreme Court? They can issue decisions, what General Sauer calls binding precedent, but I challenge the binding part of that statement.
No, we don't, because the argument here is that the president is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
First of all, Supreme Court precedents are not law. Only Congress can make law. A party to the case can violate their decision, but no one else can. Besides, the first precedent Justice Sotomayor refers to, the Wong Kim Ark case, actually violates both the Constitution and federal law. A child born in the United States of Chinese descent who, at the time of his birth, are subjects of the Emperor of China but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China becomes, at the time of his birth, a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. You see, the Supreme Court said that the child of parents who were subjects of the Emperor of China was a citizen because the parents were permanent residents at the time of his birth. But the 14th Amendment clearly states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. Not only that, but the Federal Immigration and Nationality Act states, the following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof. So how can the child of parents who are subjects of the Emperor of China be granted citizenship at birth? The answer is simple. The Supreme Court violated their oath and effectively rewrote the law. And now Justice Sotomayor wants to use that decision and the subsequent cases to effectively rewrite the Constitution, claiming that the words "and subject to the jurisdiction thereof" don't matter. She claims a decision of the Supreme Court supersedes the supreme law of the land.
And you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally violating those holdings by this court.
I believe that she meant the courts cannot stop the executive branch from violating their decisions. That is absolutely correct. Alexander Hamilton stated in Federalist Paper 78, the judiciary, on the contrary, has no influence over the sword or the purse, nor direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. Justice Sotomayor then brought up the other side of the issue. Not the idea that universal injunctions are wrong, but when they're used in support of another agenda.
When a new president orders that because there's so much gun violence going on in the country. And he comes in and he says, I have the right to take away the guns from everyone. And he sends out the military to seize everyone's guns. We and the courts have to sit back and wait until every named plaintiff or every plaintiff whose gun is taken comes into court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits.
I, too, disagree with the characterization of the merits, but she does make a point. How would the Solicitor General, or others for that matter, react if the President signed an executive order to confiscate our firearms? We could argue that the Second Amendment prohibits that, while the 14th Amendment limits birthright citizenship to those who are subject to the United States, but that doesn't deal with a fundamental issue. Are we okay with universal injunctions when they benefit us, but not when they oppose us?
We can act quickly. If we are worried about those thousands of children who are going to be born without citizenship papers that could render them stateless in some places because some of their parents' homes don't recognize children of their nationals unless those children are born in their countries. They're not going to be receiving federal benefits because that's the claim of the plaintiffs here, that of the state plaintiffs, that they're not going to be able to provide services to those children.
That is the complaint of the states. They won't be able to provide services to these children. That is the point, though, because they aren't citizens. They are not entitled to those services. Justice Kagan stepped in it a bit farther.
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
Except the court doesn't make law. In fact, the claims that people like Wong Kim Ark are citizens are themselves illegal since they violate the 14th Amendment in Title 8, Section 1401 of the United States Code. The fact that the court got it wrong over 100 years ago doesn't change the fact that these children do not legally qualify for citizenship. Furthermore, since they think they are citizens, they do not attempt to naturalize, which would give them the legitimate rights of citizens. Well, except for the chance to be president. Justice Jackson brought up another issue.
I thought Article 3 was really about limiting the court's power with respect to jurisdiction, that we say the court has to determine whether or not there's subject matter jurisdiction over the issue and whether or not there's personal jurisdiction over the defendant. And once you have those things, the court can evaluate the merits of the legal issue and issue, especially in equity, appropriate relief. Now, I appreciate that there are some prudential concerns that the court considers, but it seems to me that in many, many, many circumstances, we have not required the court to limit their relief to the particular plaintiff as a matter of constitutional Article 3 requirement.
Think about it. The question at hand is, what is the personal jurisdiction of the courts? Is it only the parties to the case, or is it anyone they can think is involved? In fact, General Sauer had an interesting comeback.
But more fundamentally than that, it is a feature, not a bug, of Article 3 that courts grant relief to the people who sue in front of them. So the notion that relief has to be given to the whole world because others who have not taken the time to sue are not before the courts is something that results in all these problems.
So many of the justices see the limitations on their injunctions as a failure, a bug in the Constitution. However, the idea that unelected judges from any level of a federal judiciary can issue orders they claim have legal force completely destroys the concept of a government's just powers coming from the consent of the governed. We delegated legal powers to elected branches, Congress the power to make law, the president the power to execute those laws, but to the courts only the power to decide controversies. It appears the Solicitor General Sauer has also missed the point.
I want to ask one thing about something in your brief. You said, quote, and of course this court's decisions constitute controlling precedent throughout the nation. If this court were to hold a challenged statute or policy unconstitutional, the government could not successfully enforce it against anyone, party or not, in light of stare decisis, end quote. You agree with that?
Yes, we do.
It appears to be drilled into law students' heads that stare decisis, Latin for let the decision stand, is the supreme law of the land. I would have liked to remind him and the justices of the Supreme Court of the Supremacy Clause. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. Earlier, this court decided in the Dobbs case that the Roe Court got it wrong back in 1973. Is it really that hard to believe that the same court has been getting the 14th Amendment wrong since 1898?